And it's really more than 48 hours, isn't it? Because as I understand it, given that the doctor won't go and make a personal notification in any likely sense, and they'd have to physically go. A phone call's not enough, I think. Isn't that right?
Right, hand
yeah,
deliver.
so they have to hand deliver. So they're not going to do that. So they're going to send something out by mail. You have to wait 2 days, 2 business days, postal business days,
Right.
in order for that notice to be effective. And then you have to wait 48 hours beyond that. So that's more likely 3 to 4, or even over the weekend, 5 or 6 days. Isn't it, in terms of how long the minor is actually going to have to be waiting?
It's just detail after detail that creates a barrier after barrier to care. Right now, we believe that the most important thing is safe professional care without delay, and this does in fact impose several delays. And that's just the simplest route, as I told you. That's if, as in the majority of cases, there is that kind of open communication. Even then, there will be that series of barriers that you mentioned. But imagine if there is a difficult situation at home. If I say, I just can't talk to my parents. I need to include my aunt or my grandmother. Right now there's
this alternative family notification where you don't know, the doctor doesn't notify the parents, notifies a relative. But how does that...
Right, well, it's a fake option, really, because at this, right now, without this proposition, that can happen. That teen can rely on another adult who she trusts, in whom she trusts, I should say. But if it does pass, then if she wants to talk to her aunt or her grandmother, essentially she has to turn in her parents to law enforcement, because the proposition leaves no room for any situation other than abuse for her to not be able to talk to her parents. I said that in a very confusing way. In other words, if I say, I can't talk to my parents, then the doctor will hand me a pen and say, please fill out this affidavit detailing a pattern of physical and emotional abuse by your parents, because that's the only way that I can go this other route and notify an alternate family member like your aunt or your grandmother.
And an affidavit is a legal document under penalty of perjury. So now the scared teenager's got to sign something that says, I understand that if I'm lying here that I'm perjuring myself and subject to law enforcement.
Right.
Isn't that right?
Right. It won't work. It just won't work.
There's, you gave me these charts. I mean, today, this is, well, you can sort of see at least the boxes here. Today, basically you either choose, okay, am I going to have the kid or not have the kid? If I'm not going to have the kid, then I get counseling, I have access to a safe abortion.
Or adoption, if that's...
Or adoption. I have the kid, and I either keep the child or go for adoption. But then under the ballot proposition, so we've got, it's probably hard to tell, I don't know, but we've got a lot of boxes here. So this is one sheet. The parents are notified, and there's a whole set of how that has to work and how many days you wait and so forth. Then on the other hand, we didn't mention this, Another option is that you can go to the minor can go to court, as though a minor is likely to do that.
I don't know many adults who like to go to court.
No, and I'm a lawyer and I don't like to go to court. So there you go. And then the court has to decide certain things within 3 days and appeals within 4 days. And I don't know any court that can handle that.
Right. That's
in California.
Right. And in Texas, where there is a similar law, they found that there could be delays of as long as 3 weeks for this process to play out. And with something as time-sensitive as a pregnancy, nobody wants that. It increases risk and makes for more complicated procedures. And I should also add that when she does go to court, the teen has to prove by clear and convincing evidence, which lawyers tell me is a highest possible standard of evidence, I guess. She has to prove that she is mature enough to make the decision on her own. So basically she has to plead her case before a judge who she's never met in an unfamiliar courtroom. We don't know how she's going to get there. We don't know who's going to pay the fees. If there are some, we don't know how she's going to get to court. It's just not realistic.
And that is it's less than beyond a reasonable doubt, which is a criminal standard, but it is high for a civil standard. Normal civil standard is if the evidence is more likely than not, kind of a balancing test. This is a higher standard that you're pointing out.
That's right.
That a child. I mean, it's a challenge for a lawyer to think in terms of what are these standards of evidence and how do you meet a higher standard and so forth. But for a frightened minor, and typically probably very frequently someone who's from a lower economic class or in a racial class. And meanwhile, most judges are still white males. I mean, so you've got a whole cascaded layer of difficulties here.
Absolutely. And that's why the San Francisco Chronicle called that particular set of details cumbersome to the point of cruelty. And I think that's really a good way to put it, because the idea that we should put a scared pregnant teen under that tremendous pressure is not only unrealistic, but we believe cruel.
The other option here we were talking about a minute ago is the relative notification. So again, this is a whole page of a flow chart here, and then that also triggers the parents being reported to authorities. So that's got more flow charts about the way that works, and and more flow charts, and it's just, so we've been through 6 pages here or something. What is the consequence to the doctor if every detail is not properly observed in these flow charts?
Well, lawsuits, basically parents have from when they find out, even if their minor child is an adult, once she's an adult, they have from the moment that they hear about the abortion up until 4 years later to sue, if they believe that the process was not followed properly.
So let's put that concretely. What that means is that 10 years later, 15 years later at a family reunion or in a tearful come together kind of moment, the child says, there's something that's been blocking my relationship with you. I have to say, when I was a teenager, you never knew this. When I was a teenager, I had an abortion, and maybe that brings the family closer together, and leaves out takes a secret out into the light. But maybe that brings the parents to say, you know what, that's outrageous. We're angry, and we're going to look into suing the doctor. And this is 2 decades later even.
Yes.
What is that going to do? What is the possibility of that? What does that do to the likelihood that doctors will perform abortions for minors in the first place?
Well, it makes it unlikely. It makes it likely, I should say, that they will fear those lawsuits, that they will be truly concerned about the liability that they'll face. We think we can't find any other reason for that. We don't believe that it's any way related to safe, legal, compassionate care. We don't find any relationship between this and the proper counseling of the teen. We don't see anything in this that actually has to do with the person that we should be thinking about most, and that's the young woman in crisis. We think it's meant to pressure both the teenagers and the doctors so that we'll have fewer abortion providers, because essentially there's a lawsuit waiting to happen for an open-ended amount of time. There's a chilling effect in lawyers' terminology. It chills the likelihood that there'll be the availability of abortions to begin with. Hasn't this sort of thing, speaking about adults now as well as kids, been a part of the anti-abortion movement ever since Roe versus Wade? They've said, you know what, we're going to try from time to time to get Roe versus Wade overturned, but even if we can't, and for many years it was clear they couldn't, now it becomes less clear, particularly if McCain wins the presidency, because you have a lot of justices who will be replaced on the Supreme Court. They've said, you know what, we're going to try to carve out around as many of the margins as we can the true access on the, in reality, even if not under the law, to the right to abortion. We're going to impose waiting periods. We're going to impose liability. We're going to reduce the number of doctors in as many states as possible who actually would be willing to perform abortions and make it as difficult in practical terms to access abortions. I mean, doesn't this really fit within that context? It does fit into that pattern. It fits into the pattern of taking away funding for everything from comprehensive sex ed to family planning to abortion services. California is one of the few states that actually does provide funding for abortion, and